You might have the best intentions on agreeing to a temporary child custody or parenting time arrangement with your former spouse. However, this can easily become a permanent situation when you really didn't anticipate that situation or plan on that outcome in the first place. Hi, my name is Thomas O'Malley. I'm an experienced family lawyer in Durham Region and the GTA. Let's see what happened to Mark and Karen. They had a 4-year-old daughter, Kira. Mark agreed that Karen could take their daughter to Alberta for a few weeks to help Karen's grandmother, who was suffering from some health issues. Then Karen decided to stay in Alberta with her daughter. One thing you can learn from Mark and Karen is, but before I explain what you can learn, let me point out that Ontario Family Court is very reluctant to change the status quo or existing living arrangements for children in general. Here's a situation that can often arise that can cause some serious problems for you. You agree to let your former spouse, the other parent for example, move to another city with your children on the condition that you review this move in a few months. This move creates a new status quo or a new situation for your children in the eyes of Ontario family law. The problem is that this move can easily become permanent, even if you both agree to review the situation in a few months. Where only a short amount of time has elapsed or passed between the deliberate creation of a new status quo and a parent's decision to challenge this new status quo in court, family court will be more inclined to presume that a restoration of a previous successful status quo is appropriate. However, the longer the child has been in a new situation or city, however it may have been created, the more closely the court will have to focus on the child's best interest as opposed to any violation of parental rights. This means that the court is more likely to let the new status quo or existing situation continue if the children are doing well in their new situation or new city in which they are living. The court found in this particular case that Mark only consented to his daughter traveling to Alberta for a short trip for the purpose of visiting family members. Mark's reasonable expectation at that time was that his daughter would return to Ontario after 6 weeks. He did not consent to any change in his daughter's habitual or ordinary place of residence. However, Mark did not do anything for a number of months in Ontario court to seek the return of his daughter to Ontario. The Ontario Family Court found that a new status quo was created for his daughter in Alberta and that she should continue to live in that province with her mother. The court found that his daughter was doing well with her mother there. The main lesson to learn from Mark and Karen's situation is that you should not agree to let your former spouse set up new living arrangements for your children or move to another city with your kids, even on a temporary basis, unless you realize that this new situation could easily become permanent. Make sure you spend some time with your family lawyer discussing this very important issue in your separation or divorce. If you have any questions about your separation, divorce, or family law case, and you'd like our help, there's a few ways to contact our office. You can leave a message on my Facebook Law Office page. That's O'Malley Family Law. Visit my website at www.canadiandivorcelegalaladvice.com or call me directly at 905-434-8837. We would be happy to speak to you. Oh, by the way, did you know you can protect your family law rights and get essential information on settling your family law issues with your former spouse with the daily, indispensable family law advice and tips at my free Facebook group? Go to Facebook and search Durham Region Separation and Divorce Legal Support Group in the top search bar. You'll find the group and join. Thanks for watching this video. Have a fantastic week. I'll talk to you soon, and take care.